And hey, it's another fine Tuesday afternoon. Don't go play hooky today. Boy, what beautiful weather we're getting for this week. Sounds like next week too. If you see that and you want to go enjoy it, earn the time. Make sure that we've actually earned it. We've done all the things that we need to do and we can get out there and enjoy what's going on. Um, so today, I'll tell you, I didn't really come up with today's topic until yesterday afternoon when I'm going, there was nothing that was really hitting me. And as I sit back and I think about it, I'm going, well, wait a minute. I got all my little things that I get from you guys. And so today I've got hopefully three things that we'll address, which will involve your input because I've got agents going, hey, Darwin, what do we do with? But first, I'll let you know I came in and my heart rate's still up a little bit because I was at a North Oakland County Board of Realtors meeting for managers, broker owners. That was the discussion of open MLS. So I hope that most of you know that there is a lawsuit in action against RealComp. RealComp is, for most of us, our MLS. I want to talk about it briefly because this is something that is hitting many MLSs across the United States. And that is where someone has sued the MLS for the aspect of, we'll call it, I'll put it in quotes, restricted trade. Because typically the MLS is owned by an association and the MLS is a separate corporation. Well, if someone wanted to get access to that corporation, in this case, RealComp, and the services they provide, they are restricted by having to join a local, state, and national association of realtors. That's what we all work under. That has seems to be becoming a repeated pattern, and they are forced to be an open MLS. And I can say I do understand that premise. So what I want you to know is with everything that I've heard, if it goes in that direction, I will tell you this is Darwin's independent opinion. I believe if I were a betting man, it's going to happen. And either we'll do it voluntarily or we'll be forced to do that through the lawsuit that is against RealComp. It's seven members, we'll call it owners of. Um, it is also involving GMAR. It is involving the Michigan Realtors and the National Association of Realtors, and obviously filed against RealComp also. What I would tell you is um, just to get an understanding and to remove any fear of this happening, it's licensed realtors. You have to be a licensed realtor in an open MLS situation. So you must, I mean, you know what? I got to use a proper term. You must be a licensed real estate agent in an open MLS, but it would remove the requirement to be a part of the local, state, and national association of realtors. Now, that means what I can tell you off of what they gave us today out of other MLSs that they've had that have just converted to this, um, about 1% of their membership ends up as a non realtor only licensees. And not surprisingly, most of those are appraisers. So, really, what you end up with more real estate agents being a part of the MLS, more listings, and more people to sell your listings, more exposure. And it's what we need. So it appears, based off of everything that I learned at this, that there are more benefits than there are any drawbacks to it. So I just wanted to give you that because it is something that's out there. It's affecting most of us in the HRC family of companies. And it's likely to begin to spread. Otherwise, the DOJ is getting their way. Let me put it that way.
Hey,
Okay.
Darwin,
Yes,
Darwin,
Valerie.
does HRC, are they going to still require us to be a member of a board? Do you know?
Well, that's the sticky part. Um, we would have to decide as a company as to whether or not we want to be a realtor company. If we're a realtor company, then the realtor or the brokerage must pay dues for each individual who's licensed within the company. Therefore, if we said, yes, we want to be a realtor company, um, we would have to pay our dues to local, state, and national. Is that decision made yet? Far from it, because we haven't even really begun to look at that depth. Matter of fact, this is the first meeting that I'm aware of, definitely that Knockbore has done, and I believe it may be the first one that RealComp's really put on. So lots of questions to be answered, and I won't throw out what the other possibilities are. But associations then would even have to take a look at, well, do we stay as realtors? It's one of the things that your question, and that is the associations would have to also take into consideration. But simply, it would still allow you to be a realtor, but it also now could allow all licensees to have a subscription to an open MLS. Okay. Any other questions toward that? All right. Let me bring this one up to you. And this is Kevin. I didn't get a chance to take a look, see if you popped on here or not, but Kevin Bentley. Kevin sent me one, and I'm going to snatch my glasses here so I can see
Here,
this
Darwin.
really clearly. You are. Hey, Kevin,
Yep.
I'm going to talk about your parent issue.
Cool.
You well here, as long as I got you, you want to share, maybe put your face on there and tell everybody what you wrote to me and what your thinking is, what the question would be.
Sure. Hang on if I can figure out there we go.
There you are.
So, um, I have a client who he and his wife are in their mid-ish 20s, something like that. Um, and they've been looking, we're kind of threading the needle to find a property for them that they can afford and et cetera, that meets their needs, that kind of thing. So I've been working with them for a few months. Coincidentally, their mother happens to the gentleman's mother happens to be looking for a property, so he referred her to me, and I'm kind of casually, I'll call it, looking for a property for her as well, because she's not making a move until the kids make their final move and decide where they're going, which is fine. That part's no issue. The issue comes up in that every time I do a showing for the kids, the mother then calls me and says, "So tell me about the property. What do I know? What's going on here? Is it a good property? Can they afford it? Can they just and I kind of give her public information. I'll call it, that, but
Mm-hmm.
it's a very touchy conversation to be able to now have to talk to the parent. And sometimes I've just had to say, look, that's that I can't talk to you about that. You're gonna have to talk to your son about what you want to know about that particular part of the project. So I'm just curious about how that works, and what your thoughts would be on what is appropriate for that conversation and what is not appropriate for that conversation.
So Kevin, that just gave me a whole lot more in his than what he had in his email. But um, guys, here's the bottom line: young buyers will often involve parents. Now, obviously, if parents are there with you on a showing, well, they invited them and they're asking questions out loud with their parents there. We're able to answer questions freely and openly. Um, in the other part, just to make sure we're all clear, what Kevin is addressing is this thing about the confidentiality. The kids are the client. The parent is not. So that's what Kevin's addressing. Am I right, Kevin? That's the real
That is
question.
absolutely correct.
Okay. So, I think another part that I would throw out would be, does mom and dad have any financial input on the transaction? Or is mom and dad going to be on a title with them?
In this case, no, but I've had it in the past. I did one last year where it was a similar situation, not quite as obnoxious on the parents' part, but they were putting up a substantial part of the down payment.
So you see, guys, at that point, that can make a huge difference. Yet, here's the key. I would probably get permission from son, daughter to discuss all matters with mom and dad. I might even put mom and dad as the client, even if mom and dad are not buying. So that what that means is I'm going to get the buyer's permission to make sure that I can discuss matters with them. Now, here's a real key to this. So, Kevin, you're doing everything right. But if mom and dad have input, and we talk about decision makers, we want decision makers looking at house. If they're going to be a part of the decision as a buyer, we want them with us on showings if it's at all possible, right? Because we have to educate mom, dad, whoever is giving input. And, look, working with mom and dad, it can be a bit of a pain. So the best way is to bring them on showings and educate them, right? Kevin, you know that one because of the number you've worked with. But when they have a financial, I guess, interest, or they're part of the decision making, then I'm going to say probably the best thing for us to do is to have them on the contract, have everybody disclosed. That way, we're truly covering our backside in regards to living up to all of our fiduciary responsibilities.
Okay.
Anybody else want to provide any input on that one? No? That was a fun one. Let me give you
Hey,
this one.
Darwin, it's Renee.
Yeah. Hey, Renee, go ahead.
I would just walk a very thin line with that because I know a lot of parents that give like gifts and all those kind of things, which obviously there's some monetary in there, but they're not like really your client or
Yes.
on any of the documents. That's between them and the lender, that whole thing. So I would walk a very fine line with that.
Yep. It's called be very careful. But if, and that's, Renee, kind of where I was alluding to. Look, if mom and dad's going to give 10 grand for them to be able to purchase this, they probably have some input. Again, work with your actual clients to see how much input they're going to have. Because parents can easily screw things up because, oh, gee, honey, look at the color of the paint on that wall in this one bedroom. Okay. You know what to do with that, right? Okay. Good input. Thank you, Renee. Let me give you
Hey,
this one.
Darren,
Yes.
Cheryl here. Just
Yep.
one more thing too regarding in writing. I would get that in writing as an
Yes.
email at least from the buyer, your client, the children, what they would discuss with the parent, because the child may not even know that
Absolutely.
the parent is calling. So if they are fine with it, wonderful, kumbaya family, absolutely. But just put that in writing to cover ourselves, because I wouldn't put the parents on the contract because the kid.
Yeah, as a minimum, it's going, I want to receive something back from them in an email as a minimum. But yeah, it's going to be in writing, where they're giving me the permission to be able to share. Absolutely. Good stuff, guys. Kevin, did
I
that
do have
take
a
care of it?
I do have a question. So my
Okay.
question of Kevin is, are the kids aware that the parent is calling you and asking you these questions, and how do the kids feel?
that part?
It's in this particular case, the most recent one that I'm working with is it's a touchy situation. Without getting into a whole lot of family stuff that I now know and don't want to, there's some contentious conversations between the son's mother and her daughter-in-law. Just some weird tension going on there. So they're aware of it and they understand it. And the conversation I've had with them is they're okay to a certain point having her know about it because they're keeping her informed on where they're looking. But when it crosses over into finance, that's when I kind of shut down with the mom. It's like, look, I'm not telling you anything. That if you want to talk about what they're approved for and how they can get their loan, you're going to have to talk to them. So,
Well, the
Good
magic
job.
word was mother-in-law, daughter-in-law. I heard that.
yeah.
Yeah.
Right. Okay.
Yep.
All right. Well, let's do this. I'm going to do a share here. This is one that came to me and it was like, hey, wait a minute. Can this happen? So I'm going to show you a redacted addendum to a purchase agreement because this is really all we need. So everybody's seeing that? Okay. So what this is a contingent sale addendum. And it says they've entered into a purchase agreement. Parties decided certain terms, and therefore, it is contingent on the sale of a separate property. Other stuff you can't see isn't important. Dates, obviously, in regards to these, are always important. Somebody holding a deposit, that there's going to be a mortgage. Here's how we're going to handle the home inspection. Satisfaction of the contingency. So here's what it says. Let me click off of this so I don't do anything else. It won't do it. Figures, wouldn't it? All right. So if the purchase home is sold during the contingency period, this contingency shall be removed in writing and the purchase agreement shall then become contingent on the closing of the sale of the purchaser's property. That's a key part. They're still saying, so we've removed it, but we've got to close on it now. And we're going to do that within 30 days of the removal of the contingency. Okay. Then there's paragraph 5 on this one. It says, if purchaser removes this contingency without selling their present home, they're agreeing to do it within 15 days of the removal of this contingency. In such event, the purchase agreement shall no longer be contingent upon the purchaser securing a mortgage should the closing not take place within the time period set forth, 15 days. Herein, the seller may declare the purchase agreement null and void and retain the purchaser's earnest money deposit. Okay? So, this is real life, guys. Here's what was received. This is just redacting the parties, redacting the address. We hereby remove the contingent sale clause. This agreement of sale is now contingent upon the closing of the seller's present home by September 15th. Here's the date it was done. Here's the date that they've removed it. But look at this. What's the issue?
It's not within 30 days.
That's the key. It's not within the 30. It's definitely not within the 15. But the issue is they've removed it and then they put the closing beyond the 30 days. So they're removing it. Let's call it end of July. Just that alone, guys, we've got at least 45 days. So when this came to me, it was, can they do this? Sorry, I just noticed my name was still on my shirt. So this is what you have to take a look at with all of your agreements and how much understanding the detail makes a difference. What would be the risk to the seller having signed this?
You've now extended you've changed the contract inadvertently, right? I
You
mean, because
got it.
they agreed to it without any pushback on the September 15th. So the original contract is now amended.
Yeah. Now, here's the date that they did it. The original purchase agreement says July 14th, or excuse me, July 24th. They're removing it just 5 days later. Now, let's say it wasn't invoked because of another offer. They just decided to remove it. What do you want to know?
What are the
Yeah,
chances of
Cliff, I think you lipped it there. Why? Right? Why are
Yeah.
you removing it? Did you or do you have the house sold? Or are you just moving forward because you want to make sure you get the house? Do you have liquid funds to be able to close this transaction? Those are some pretty good questions. But I'll share with you in this case, they received notice that another offer had been received. In which case, they're now going, oh, well, then we'll remove it. And the question is could they do it under these terms? Nope. Because in one case, it's either 15 days you're closing or 30 days. Within 30 days, you're closing. Does that make sense, guys? How about any questions or discussion on that? Any ahas that you might have?
So what's the play here when a buyer comes in with one of these and gives it to you, and then you see that, hey, the date is past the 30 days on there. Do we just refuse to sign it and say no, put it back to the right date?
Yeah, it would be a call. Hey, Jimmy John, I just got the contingent sale release, and I appreciate that the buyers want to move forward, but I got a question. You've got it now as September 15th versus either 15 days from today or 30 days from today. Can you help me understand what's going on? And in the end, I'm going to go, yeah, well, I don't think my seller's going to agree to this. You either have to close within 15 days or 30 days because that's what your original contingent sale addendum said. And then I'm going to look for an explanation. And if they say they can't do that, then I say, well, if you'd like, you can either forward to me the mutual release or I'll put one together and I'll send it to you because we are going to move forward with this other offer. And of course, that would be within the appropriate time. And then, here's the key, removed in writing, and the purchase agreement shall then become. The only thing I would look for is I want proof that their home is sold, or I want that proof that they can do it. Now, may not hurt with the aspect of the 15 days, but give me the proof. Let me know. When I get these, it's, hey, great. So you've got it accepted. But again, I don't even, by the way, me representing a seller, guys, I don't like to give 24 hours, 48 hours, 70. I don't want to give any time. If you can buy it, buy it. If you can't, well, then look, in the clause library, there is a clause specifically written to take care of the seller so that the seller can leave the property on the market because no notice is necessary to be given. Now, am I still going to make sure I get a mutual release? Yes, I am. When I accept the other offer, am I going to state that it's subject to the full release of an existing offer? Yes, I am, because I'm going to cover my backside both ways. Okay. Matter of fact, that's twice now where I don't think everybody has heard of the old Latin proverb. Anybody know it? Jason, you've heard it a lot. What's the old Latin proverb? You remember?
What are you talking about again?
The old Latin proverb,
Or,
anus, protect
oh,
us. Yeah. Okay. Yep.
CYA?
Yeah. CYA, you hit it, Lydia. Yeah. Anus, protect us. Do all the things necessary to cover all situations. Take care of your backside. That's what the old Latin proverb is for that. And that's what we're looking at with this particular situation. So, any other questions regarding that one?
Yeah, I do. So if you have an offer, how and why did the buyer know that you have another offer?
Through notifications. So these basically, if I generalize what it says, my offer is contingent and you can still continue to market it. But if you're part of the Real Comp MLS, they force you to actually make it contingent, continue to show, otherwise a CCS status.
Okay,
So if we market CCS, here's the reason I don't like it. We just pulled it from the market. We might just as well market pending. How many of us show any contingent continue to show listings? So we're really effectively removing it from the market. It's the reason I don't like to have an offer accepted 24, 48, 72. Now, have I done it? Yes. I did it with a property that was on the market for 90 days. We were going to reduce the price, and yet they were willing to pay the full price. Talk to my sellers, drawbacks. Yet, here's all the benefits. They said, well, I think it's worth a $15,000 risk. And in the end, it did work out for them. So, but I'll tell you what, we looked into the property that they had to sell that wasn't even on the market yet. And we covered that aspect that it must be on the market within 2 days, or 2 weeks. It was in another state. But we looked at the property and went, well, geez, there's no issue to this home selling. So, yeah, I think there are situations where it's worth the risk, but that's what we always have to weigh when it comes to accepting contingent offers.
Darwin,
Yes, ma'am.
this contingency was sent in with the offer or after the offer was made?
Yeah,
And they
so
sent it.
this addendum was part of the original offer.
Okay.
Yep. And then after, what was it, 4 days, they sent over this addendum to remove the contingency.
I see. Okay.
All right. Everybody good? Well, I thought I was still sharing and I wasn't. But anyway, yeah, that's the specific situation. And then I've got one more. Lydia, do you remember sending me one back on July 31st?
well, which one was that?
Ah, come on, Lydia. We don't talk that much, but if it's okay with you, I want to share that one.
Go ahead.
All right.
I'm trying to
So,
remember which one it is.
yeah, it'll come back to you.
Okay,
I won't use any specifics, but there was a home that was listed. We're going to use an example of 100,000, multiple offers. Lydia's buyer, let's say, made an offer of $25,000 higher. We'll call it 125. Let's see. Lots of inspection revealed some issues with the offer. Same day, few offers, the process misspoke, but the appraisal came back in at 103,000. Okay. So now we're renegotiating, right? So we've got listed for 100, offer of 125. It got accepted, did inspections. Appraisal comes back at 103,000. Negotiation starts. Seller says, well, let's see, could the buyer do 115? What are you going to say? Nope, can't do it. Well, could they do, let's say, 110? Nope, can't do it. Best my buyer is going to be able to do is 103, which is the appraisal value. Okay. So let's say the listing agent isn't really happy, and we could all understand that, right? I wouldn't be too excited, but they should have thought about how we structured the offer when we made it. So the listing agent says, well, here's the bottom line. It's 103. You can kill the deal, put it out for 100 or put it back on the market. Or could you go back for a different price? So can the listing agent / seller walk away from the offer? Question number one, can they walk away from the offer? Can the seller, at their sole discretion, walk away from this offer? No, because it did not appraise. The buyer is saying, I'm not willing to do any more than 103,000. So Christina is stepping right out and saying, yes,
Yes.
she can, if the buyer and the seller cannot come to an agreement. How many agree with Christina?
I do.
I do.
Yeah. Yep. That's a big key. Okay. And that's where this was at. It's just, and Christina, I can't put it any clearer than what you've done there. If the seller and the buyer cannot agree to come to a resolution on this, seller can walk away. Okay. Now, can the seller walk away if the buyer was willing to still pay 125? Not as long as he can close.
Right.
Right? As long as he can still close and he was willing to do it. Maybe Lydia and her buyer were still going, hey, I like this property. I'll still buy it. I was trying to play hardball. Hey, great job, seller. You negotiated hard. I'll still buy it for 125. Okay. The bottom line is we're talking about our purchase agreement, and that's the reason that we know what the answer would be. However, if it was a different purchase agreement and we were on the seller side of this, we'd have to read and see what the purchase agreement actually says. So anytime you come with a question, if you were coming to me, obviously you're going to your branch manager, you're taking the paperwork with you because we need to see what the paperwork says. Now, let me give you one other one because I think this is really
before you
important.
go on,
Yeah, go
you
ahead,
have
Lydia.
to give them the end of the story.
Oh,
I am happy to say that we closed. I'm happy to
hey.
say that he got it for 103. I'm very happy to say that he billed the seller for cleaning the place because it was a mess and it was not broom clean. So we went to closing, bickering back and forth. And then my buyer appealed to the seller and he said, I just want you to repay me for cleaning your place because it was a mess. She had not seen the place in about a few years, like maybe 5 years or so. The agent had not gone back or had not checked after the people, the dumpsters moved out. I hadn't told her. And she said, I just want to be done with it. And we closed.
Well, there we
And
go.
he got reimbursed for cleaning the place.
Fantastic. That's a good real estate agent right there.
There you go.
Awesome, Lydia. Thanks for sharing. And guys, as you come up with these, please forward them to me because we're looking almost 2 months before I got an opportunity where we could address these. And yet it's an opportunity for all of us to learn off of the experiences we have. So great job that Kevin brought to me. Great job, Lydia. In the end, what I shared with you in regards to this contingency is another. But one last quick one. What if we take Lydia's scenario for getting the appraisal, but that the buyer did the 125 offer, did an inspection, and then said, you know what? There's a lot that's wrong with this house. I'll tell you what. I need you to reduce the price down to $110,000, $15,000 less. What are the seller's options? You guys know. Still
And
pretty simple, isn't it?
They can either agree with it, they can negotiate a different term, or they can walk away, right?
Oh, so close. You were really close until option C.
All right, so the seller can't walk away at that point. The seller, but the seller doesn't have to agree to the other, and then the buyer's going to walk away.
Bingo.
Okay.
So it's very similar that if the buyer and seller cannot agree, who has the right to walk away? In most purchase agreements, it's the buyer. So if they cannot come to terms, the buyer has the option of walking away. So here's the reason I brought this up, because it's really probably been one of the most common ones that I've had brought to me as a manager doing what I do. It's, well, I'm walking away. Nope, they don't have the right to walk away. The seller doesn't have the right to walk away because the buyer can still decide to move forward with the purchase as it is. It does not become a, well, you made a counteroffer, and this is the part that I really want you to become really clear with. You, the buyer, made a counteroffer based upon your inspection. I'm not agreeing to it, therefore your purchase agreement is dead. No. And that's what a lot of sellers will tell you, your own sellers will tell you they want to do, and they cannot. And that's what listing agents will tell you that they want to do, and they cannot. I haven't seen a purchase agreement that would allow that to happen. So I'm using a blank statement again. Bring the paperwork when we run into it, but that's the importance of you knowing what that inspection clause says and what even your mortgage clause says. So that's what I got for you guys today. Let's do a little open Q&A if you have any. That's where you do this. One.
So Darwin,
There it is.
Danny and I had an issue this past week.
Okay.
We had buyers we've been working with for 6 months and showing them different properties based on their desires of where they wanted to live, price range, type of housing. They then last Friday, or the Friday before last, sent us a text. Good news, we found new construction in an area outside of the area we're looking at, and that they still want us to sell their house. So we, of course, congratulated them and then proceeded
Oh, I'm
to.
so happy for you. Biggest lie in real estate.
So then we, tried to find out as many questions as possible. Then Danny contacted the sales office of the builder, thinking that it was just the builder and our clients, but it wasn't. Apparently, a realtor showed them.
Ooh, this is good stuff.
Yes. So we tried to get the name of the realtor from the builder, and they wouldn't tell us. So they said that we'd had to go to our clients, and our clients wouldn't tell us who their realtor was. And our clients were very upset that we were actively interested in getting
Compensated.
any compensation. So then they were like, well, we don't want to deal with you at all. You're not going to list our house. So big drama ensued, and we got a hold of them and explained, well, we showed them the contract. We emailed them the contract that they had signed with us. which was due to expire October 31st. So the husband showed his true colors and said, well, we'll just wait till November 1st to buy on the new construction. Well, the builder obviously wants to close in this quarter, not fourth quarter. So they approached us and said, look, if we can get them to agree to list their house with you, will you release them a mutual agreement? So my question is, we got them signed to list their house, but what if they back out on that? They obviously backed out on the first one.
Boy, I'm so glad you brought this up. This is the one thing I miss about being in sales meetings. I always called it This Week in Real Estate. And yeah, Jason, Cliff, you guys know, others have been with me, when I was managing. The best way for us to learn is by sharing these types of scenarios. So please do what Valerie has just done, what Lydia's done, what Kevin's done. Send this stuff to me so that we can share with others and have the This Week in Real Estate type of hot topic. Okay. So I'm going to simplify question number one that really came up, and it was this. Is a buyer representation contract worth the paper it's written on? Yes, and thousands of times more. Okay. It is a binding agreement. Yes, it allows us to pursue our compensation, probably now more than ever since we've had the settlement, and that we now have to have buyers fully informed and signing an agreement that they are the ones who are compensating us, and then determining how they want us to receive that compensation, either directly from the buyer, or in our case, what we know is about 95% of the time, okay, maybe I can say 93% of the time for cash offers, but very little is a buyer going to compensate us directly. So you have the full right to pursue your compensation. That is the first thing I want you to know. There is a reason that as a brokerage, we've now came out after everybody's got into it and we knew what the market was doing, that as a brokerage, we made the conscientious decision to no longer, as a listing broker, sign a broker compensation agreement. Because now we got to look at procuring cause, knowing in the code of ethics, NAR has not changed how procuring causes actually work. So if we sign a broker compensation agreement, we pay a buyer's agent, buyer's broker, and then all of a sudden discover that somebody else had procuring cause. What we don't know is who's going to pay if the broker agent who had procuring cause won a procuring cause arbitration. Who's going to pay? That's why we won't do it. We're not going to sign them any longer. Okay. So let's carry the conversation a little bit further with what Valerie and Danny went into, because my first thought when you described it, that you said, well, they did this, but we found out it was a realtor who introduced it to them. Well, the first thing that you're doing there is, ouch. Now what do we do? Second thing was, it was the builder, then it was an agent, but then you brought up the aspect, but we still want to list the house with you. So now it's a business decision. And in the end, uh, here, just a personal opinion, and that's all it is. It means nothing, but personal opinion, you made a good business decision to get paid something rather than potentially ending up with nothing because we don't know what we would have gotten. We don't know what we would have gotten had we pursued it. And that's always the, I'm going to tell you most of the time, it's try to do it without court because as soon as you get an attorney involved, there goes 33% of whatever you're going to receive. Not that they fix their fees or anything. I don't know why they all have 33%, but for some odd reason they do. Um, I mean, not that that's price fixing or anything, but restricted trade or anything of the nature. I'm not insinuating anything. But anyway, you know that you're going to give a third of it up, of at that point, of whatever you settled for. And typically, you're probably going to settle for less. Probably. Again, what's the circumstances? What's the situation?
Darwin,
So
could you
the
ask the agent for a referral fee?
that is one
We
very
did.
quick, very simple way of doing it. Yep, absolutely, Crystal.
We did ask, and the husband refused to present that.
Wow. um, I would probably um, reach out to the broker agent.
No one's
But
revealing that name to us.
oh yeah, because you didn't know who it was. Yeah, so it wasn't even a possibility. I forgot that part of it. So, yeah, that's often what we do, and we explain the position and why we do it. Um, and I'll tell you that I had one while in Rochester. It was, but I'll tell you, it was still pre-settlement days in very clear-cut procuring cause for one of our agents. And we're talking on a $500,000 plus home. So obviously we're talking $15,000 in compensation that we're dealing with. Very, very clear. It was our money. We had procuring cause all day long. But in the end, we settled for 10,000. And of course, what do we have to give away? A third. So in the end, we basically got half of what we should have received in the first place. So, it literally, and I know Valerie, and I'll tell you what, she's one of the best at thinking all this through, getting the help. And in the end, she did all the things that she could do and ended up with the right circumstance, which is let's take what we can, which is the listing and get full compensation on that. And the only other, whether or not it would be worth it, I couldn't tell you. I don't know what would happen if you were to try a procuring cause on this situation. Um, and of course, the only other is, well, no, there is no other. You've got the listing. We're going to live with it, right? That brings up the other part, Valerie, because your last question was, could they back out of this? The answer is no. Okay. In reality, they couldn't back out of the buyer representation contract. They did something stupid that they probably didn't even realize that they were doing because they're not familiar with how concrete that is. When it comes to the listing contract, people have always pretty much known they've signed it, they're responsible for that, but they think that they can fire us at any time. So just remember, it was a mutual agreement. It took two parties to enter into that mutual agreement. It takes two parties to leave it. And that's what a lot of buyers and sellers, I'm going to say in this case, sellers don't understand. Both are mutual, and it takes buyer and seller with us if either party or any of the parties wish to leave that contract. And matter of fact, with our updates that we've done the last couple of years, I pretty much tried to make that a highlight with what we've done on our revisions of the purchase agreement. So it's mutual agreement. bilateral. It takes mutual agreement, bilateral, to leave it. They cannot fire us. And by the way, when I talk about the settlement on that $15,000 deal, that was a settlement between all of the parties. But we were really ended up negotiating it directly with the buyers. But we didn't have another listing that we were going to get, number one. Everything was already done. So that was the big key and the reason that we settled, but it ended up, we were going procuring cause, then the buyer got an attorney involved, and then the buyer says, wait a minute, this is really against us, not against the buyer broker that they ended up with. So good stuff. Gang, with that one, it's 12:51. Anybody got anything else that we'd
I have a
like to hit
question.
today?
I just
Yes.
want to be really clear. We are not signing the broker agreement anymore.
Buyer
But we
broker
will-
compensation
Right,
as
But
a
we will-
listing broker.
right. But we will write into the purchase agreement that the sellers paying the compensation, right?
Absolutely. That is I would bet, I don't get to see all the PAs, but I would bet that that's going to happen at least 90% of the time. The other is going to be that it's a cash deal, so the buyer is compensating directly.
Okay, great. And then the last question, why can't the seller go back on the deal? And the McBain, what was Valerie saying? Why? Because
Why could
what
the
would
seller
stop them?
not?
Yeah, how come you're saying that the seller cannot get out
The
of the
seller
contract
cannot
because it's
leave the
mutual?
terms of the contract.
But suppose they decide, you know what, we don't want to show the house because we don't want Valerie to get anything from it. I mean, like, what's the
Now
stop them
they're in
from-
breach of the contract
Okay,
because it says the seller will make the property available. Well, if they are
Okay.
denying showings, then they're not making the property available.
Darwin, I have a quick question as a follow-up to the broker compensation
Yes.
that we're doing away with. What is a good way to respond then to agents, buyer agents on your listing who say, what is the seller offering?
Anybody want to take a shot at that one?
I will only say based on full price and terms, what they're willing to offer.
I like that. I'll expand on that a little bit further.
Darwin?
Kevin, were you going to throw it in there too?
This is Renee, and if you watch the Mar attorney, he says that if you want to respond, it should be up to whatever you agreed upon, a percentage or whatever.
Yeah, as a matter of fact, my suggested verbiage is to know what the listing contract set. In a listing contract, if let's say that we've got our 6 and 3, the contract says that the seller has directed me to offer 3% for a full price offer.
But that's only if your seller says that, because it doesn't really state that in our.
Actually, that is the seller directs broker to,
I think the verbiage is off.
yeah, it's definitely a direct. Let me see if I can pull it real quick here.
But that's if it's in the listing agreement too, which we're not
Well,
doing
that's
anymore.
that, but it is in the listing agreement. If it's what it says, that's the key. And so that's where, let's get it. Oh, come on. I don't want to do all that. Go. You just love it when it's like, you sure you want to do this? You sure you want to do this? Okay. Let me get the PA up here for us. HRC forms. Purchase agreement. And now let me get our share for us. And And that is, there it is. Okay, everybody see the purchase agreement? What? A purchase agreement. It's not the one I need. Sorry. Forms 2025 listing contract. I'll use this one. Yeah, I know. Back to share. There we go. Now we should be seeing it. So here's where we come up with what the amount is. And then down here's where it would be. And owner directs brokerage firm to offer a portion of listing broker compensation to his compensation for the producing a, okay? Said offer shall be. All right. So here's what it says. You're giving me the full authorization to market your property at this price and terms, and I'm directing you to offer blank percent for that amount that we've agreed to here. So to say my broker, my seller has directed me to offer blank percent for a full price offer would be correct. That's the terms of the agreement that we've signed. And the reason that we want to say it that way, let's just say that it was 3% and the offer came in less. Does the seller still have to offer 3% by our contract? No. And then I would encourage you to remember this. The listing agreement is between who? Broker and seller.
Yeah.
Right? Who's the purchase agreement between? Between the
Seller
buyer.
and buyer.
You got it. Seller and buyer. So when does that purchase agreement become binding?
When they both signed it.
Yeah. So here's the reason in our verbiage, if an agent calls and asks me, and why what you tell them is so important. We all know that when it comes to real estate, deals on real estate must be in writing. But that's only on real estate. What you've offered is whatever you've stated. And Mar Legal Counsel has said you might find yourself in court because you said that you'd compensate 3%, and then in the end you only did 2.5%. And you had a verbal or oral agreement which may be found binding. And yet what the seller in the end decides to compensate really is up to them, and we don't want to have to fight with them. And the only thing that they said, we'll allow you to compensate blank percent of your compensation and direct you to offer that for this price.
But if that's not in, if we're not putting that in the listing agreement and we're waiting for buyer agents to put it in the purchase agreement, do we just say depending on price?
Wow, I haven't thought about it. Let me pull it back up. I'm going to share it again. And we'll talk about what we should be getting. So there, I think what you're talking about then, Stacy, is what if the seller says, I'll only give you 3% and do not offer. Is that what you're referring to?
Yes, because that's how we've been doing it.
Oh, don't do that. Here's what I'm saying. We want our 6% up here. And we can talk about this as a company because it's our company. We want our 6% up here. Everybody Know why?
But I thought we were doing away with the broker to broker.
Nope. We're not going to sign a broker compensation agreement because then we're bound for that payment as a listing broker. So we're not doing away with offering compensation. We're still going to do 6 and 3. We won't do that. We're just not going to agree to pay the compensation. It gets a little weird with what I'm saying, but it's a matter of binding us to compensating with a broker compensation agreement. By offering, and we tell them, look, do it through the purchase agreement, we're not on the hook for that. Does that make sense?
Not really, because I thought we then had to remove or change that listing agreement. Once it's in the purchase agreement, change the listing agreement to 3 so that not on the hook for, the seller's not on the hook for 9. That's the way it was explained to me.
Which office are you in, Stacy?
East Lansing.
Okay.
Wait a minute before you go. Why is she saying 9%? She's saying 6 and 3. Why is she saying 9?
Well, the reason that she's saying that is that, see, the seller, and this is where, okay, let me explain what you just asked, and then we'll go back to what Stacy said. So there's 6% here, and then the purchase agreement comes in and it says 3. 6 plus 3 is 9%. So that's where Stacy's coming up with that. Does that make sense, Lydia?
No.
Well, here's an agreement that says the seller's going to pay 6% to us as the listing broker.
Right.
Then a purchase agreement comes in and it says that the seller is to pay the buyer broker's compensation of 3%.
Yeah, but that's 3%. That's 3 of the 6, not 3 and 6.
But this is what Stacy is saying. The contract still says 6, and a separate agreement says 3. That's a total of 9%.
The separate agreement is between who and who?
That's between the buyer and the seller. See, and that's what the issue is and what Stacy's been taught. Because in theory, it says 6 and 3, 2 separate agreements, 6 and 3 together is 9%. Now, let me address why that doesn't happen. It is because of this portion right here. There is the understanding that when the buyer asks the seller to pay that compensation directly, we're not charging the 6 because that is the 3% that we've been directed to offer as compensation for the buyer broker. Therefore, it's 6 less 3, or we keep 3 and the seller's giving the 3 away. Total of 6%. So what I would tell you, Stacy, is as a company, because of that, we're not going to charge 6%. If a seller said, well, wait a minute, if a seller actually sat back and thought about that, and they said, well, wait a minute, I got to pay you 6 and them 3? Well, that's 9%. And they really said, well, listen, I want that adjusted. I'm going to adjust that. I'm going to sign something that says we're keeping 3% as the listing broker, and that's it because you're paying 3%. But we don't need, I'm going to say it's not a requirement for that to happen. Now, if my if my manager is telling me to do that, by the way, that's the way it should be done. Okay? I'm going to get in trouble for this now. But yeah, Stacy, I understand it. It's not a necessity because of who we are. And I guess I would liken it to this. How much can we get from a buyer? What's the answer on that one? How much can we collect from a buyer?
Whatever is stated in our buyer
Whatever is
agency
stated in a
agreement.
contract. So if a seller was offering 5%, can we keep more than that? The answer is nope. We can only collect the 3%. That's all we get paid. Well, the same thing is we know the intent is that we're getting 3, but the reason it still says 6, by the way, it says, should we procure the buyer? We get paid 6%. So we're covering ourselves so that if we'll use Cliff, Cliff has both sides of the transaction, whether he's representing the seller and the buyer, or he's representing the seller working with the buyer. He wants his full compensation because he procured the buyer. Well, the way that we do that is by having our compensation sitting at 6%. Because the same thing happens if Cliff has the seller and John has the buyer. Well, we're basically already covered as a company because we're under the same umbrella. Okay? Stacy, you went silent on me, but does that at least help?
Sorry, I was looking at the document. Kind of. It's just, I thought there was a separate section for in the listing agreement for when you have both sides and what your compensation will be.
Yeah, it doesn't, as it puts it, let me see if I can pull it back up here again. It's really addressing it from that side. Did I close it out? I did. Let me go back. It's all in the one clause or one paragraph. So it is all in here. This is the part where it's brokerage fees not, if during the listing, if during the term of this listing, anyone produces a buyer who is ready, willing, and able to purchase the property at the listed price, terms, other terms are exchanged, which the owner consents in writing, owner agrees to pay brokerage. Okay? Because it could be that the seller found someone. Well, we still get paid our full compensation of 6%. So remember, it is an exclusive right to sell. And if we go back to our pre-license training, we know that means that if we sell it, we get paid. If anyone sells it, we get paid. Mr. Seller, if you sell it, we get paid, and we get paid the full compensation. I will share this. I wish I had better language to cover that situation. But when we make any adjustments and any updates, we're looking at any other purchase agreements that we can get our hands on and see if anybody else has made a way of clarifying that. But I haven't seen anything come out different from GMAR, RealComp, or from probably the most important one, Michigan Realtors. Because those are very specifically drafted by attorneys. And they haven't given us anything different. Matter of fact, last I knew, unless if they did a recent change, that listing contract started with their verbiage and dialogue. So that would be exact to what they have had. And just our little having to personalize. Okay. Anybody else got any other questions? We've kind of went past overtime on the overtime. But this is good stuff, and you don't always get this kind of a format where you can open up and ask these kind of questions.
Yeah, this was very, very good. Thank
Awesome. You. Absolutely. Well, I appreciate you guys. Thanks for hanging out with me today. Again, we got some beautiful weather. Hopefully you got an opportunity, but I'll tell you what, you know how we always finish things. Go talk to people. Use the opportunity to get outside, enjoy the weather, and do a little bit of door knocking. Have a little bit of fun with it, and go see what kind of business you can get. With that, see you guys.
Thank you
Have a
very much.
fantastic week.
Bye.
Thank you.
Thank you. Take
You're
care.
welcome.
Bye, thank you.